We are really excited to work with ACC on this event. We definitely can't wait to get back to seeing all of our friends in person. But in the meantime, a little bit of tea on a Tuesday afternoon and an hour of CLE right from home or from your office is definitely a lot of fun too. So as Susan mentioned, we're covering your spectrum of experience today. I'm going to kick this off with a little bit of basic information about how food is regulated in the US. And then my colleague Bill is going to talk about what to do when the FDA inspector who's conducting an investigation of your company shows up at the door. And then finally, Morale is going to end on a bit of a lighter note and take us through some adventures in food advertising. So as we get started, we just wanted to kick this off on a bit of a humorous note. This is what we think we do versus what we actually do most of the time. A lot of us who are in this space are working in food law because we wanted to do things like work on a recall of products or work on a food safety issue. But a lot of the time it does come down to arguing about what goes on a label and whether or not we are okay with making claims. A lot of the liability and a lot of the headlines in this space actually come from advertising and labeling faux pas. So we appreciate the opportunity to be here today. Our practice kind of grew out of us seeing this need in clients in DFW about 10 years ago. So food and drug regulation seems like a weird thing to go regulate food, right? Regulate what's on the label, what goes into it. So where did this start? I always like to keep this in mind because where it started is really still what's important. Food and drug regulation has always existed in the US from early times. But in 1906, Upton Sinclair wrote a novel. It was intended to expose poor working conditions of immigrants in meatpacking and other types of industrial jobs. What it really ended up doing was providing an expose on the food industry and on meatpacking plants at the time. There were passages in it like, there was never the least attention paid to what was cut up for sausage. There would come back all the way from Europe, old sausage that had been rejected, moldy and white. And so, as the quote from the author says, he aimed at the public's heart for the immigrant workers, but instead ended up inspiring a movement toward better regulation of food in the US. As a result of that, just a year after the publication of The Jungle, saw the Federal Meat Inspection Act, which still exists today. And today, meat, poultry, and eggs are still largely regulated by the USDA. And every meat, or a lot of the meat that you eat, comes from facilities and manufacturing facilities that still have a USDA inspector on site who looks out for food safety issues and inspects the meat that comes out of that facility. But most foods are actually regulated by the FDA. The Pure Food and Drug Act also came largely as a result of the jungle, but also as a result of things that had gone on in the drug space with adulteration of medicines. And as a result of the Pure Food and Drug Act, the FDA, as we know it today, was established. Today, the FDA regulates not only food, but also most aspects of drugs, medical devices, biologics like the COVID vaccine and plasma donation, tobacco, e-cigarettes, a lot of cannabis products, stem cell products, cosmetics, dietary supplements, bottled water, infant formula, microwaves, and other radiation-emitting devices, and veterinary products. They regulate some 20 to 25 cents out of every dollar consumers spend in the US, and about $500 million worth of food products. And for food companies, the FDA's regulation is pervasive. It impacts every part of their business and what they do as far as sourcing, producing, distributing, labeling, and advertising the products that the food companies produce. And then more and more, we're seeing that the FDA's reach is extending to the activities of retailers and restaurant chains who traditionally thought themselves a little bit less under the FDA's influence, are finding in recent years that that's not so much the case. And then there are other agencies that also regulate food products and have a pretty heavy influence, including notably the FTC, which takes an interest in advertising, EPA, which shares jurisdiction with FDA over a lot of products and over important things like pesticides and other chemicals, and of course, USDA. But we'll focus largely again today on FDA because that's what impacts companies the most in this space. What to know about FDA regulation of a food company? First, most of the current authority stems from the Federal Food, Drug, and Cosmetic Act, far-reaching law in and of itself. But under that act, the FDA has promulgated its entire title of the Code of Federal Regulations, 21, and within that, there's an entire section in the 100s dedicated to all types of food regulation. This is everything from food packaging and what can go into the plastic that wraps up a Twinkie, to how you make ice cream and whether or not it meets the standard of identity, to whether or not color additives are certified. Now, because the regulations in and of themselves, as extensive as they are, can't come anywhere near addressing all of the issues that the FDA needs to address for industry, the FDA also relies heavily on guidance documents. Guidance documents have certainly been a hot topic over the past several years, as the role of those guidance documents and the lack of public comment and oversight has taken center stage. We've seen a lot more of that recently with respect to COVID, in the food arena and also with other types of medical products, and especially masks and gloves and other PPE for the pandemic. The FDA has relied heavily on its ability to promulgate guidance documents. And so those are a key part of understanding the regulatory space. And if you're ever tasked with someone telling you, well, the guidance documents aren't mandatory, they're voluntary, we can do this differently, then as in-house counsel or any counsel to a food company, the job is always to say, all right, well, then exactly how are we going to meet the FDA's enforcement expectations and their understanding of the regulations if we're not going to do what the guidance document says, since that's what the agency itself thinks is important about how its regulations are interpreted and enforced. So the basics of food, what exactly does the FDA regulate? I already said it is really wide-ranging, that's true, but the basics is that most of what the FDA is going to do comes down on regulated or registered food facilities. So any facility that processes, packs, or holds human food is going to need a facility registration if it introduces that food into interstate commerce. In addition, most states, including Texas, will require a separate permit or license for similar facilities. And this can be a facility that actually produces and manufactures and distributes food, or it can be a series of warehouses. Food safety, of course, this is where the regulations really stem from, right? This is the inspiration for the regulations. And this regulates the manufacturing. FDA has extensive regulations around manufacturing. Now, about a decade ago, the FDA modernized food safety, or was at least given direction by Congress and President Obama to modernize food safety with the Food Safety Modernization Act, or FSMA. FSMA substantially expanded food regulation in the US. There are new rules, 7 final FSMA regulations that impact all types of different facets of industry, from sourcing food from foreign suppliers to produce safety and sourcing water for crops in a field, to having recall plans for a food facility, onto intentional adulteration protection, which is actually to say food defense, preventing those who seek to harm us or commit acts of terrorism through our food supply from getting the opportunity to do so. So, as Bill will discuss further, what makes this space really unique for attorneys who practice within it is that it is not just a company itself that can have liability for significant violations of the Food, Drug, and Cosmetic Act. FDA's options range from suspending facility registrations, seizing products, enjoining activities, pushing a company to recall products, which is typically voluntary but rarely mandatory, and even working with the Department of Justice on occasion to investigate a company or what the FDA considers to be responsible corporate officers under the Park Doctrine. Essentially, what's important to understand is that if the FDA believes that there's been a serious gap in food safety that was caused or contributed to by a company's practices or their lack of compliance, or perhaps repeated problems that weren't addressed over time, the FDA will often seek to investigate and hold accountable the officers of the company itself. And this sets this space apart from other types of investigations, in part because of how a company may say, well, we've delegated certain tasks down to our plant level quality assurance personnel, but then truly the FDA still holds those who are at the corporate headquarters and who are in a position of responsibility accountable, or attempts to. So different types of inspections and enforcement powers. The FDA does everything from routine surveillance, right? Routine surveillance could be testing a shipment of products upon import. It could be visiting a facility regularly, or checking in with the company and saying, hey, can you send us a copy of your required procedures under this section of the regulation, to recalls, warning letters, seizures of product, injunctions, criminal prosecution, or fines. And then state agencies typically have a lot of responsibility in this space as well. They can detain food, they can suspend or revoke a permit, they can have contracted agencies inspections with the FDA, where a state regulator will come in and do what industry not so fondly refers to as a swabathon, where they look for bacteria in facilities. And so there are a lot of different types of consequences. So the best thing, of course, to do when you're thinking about advising a food company or food production company is to imagine upfront all the different laws and regulations to which your company could become subject, or its products could become subject, and to make a great plan. We know that doesn't happen. Our phones usually ring true to form and true to what you would expect on Friday afternoons or just before holidays. And our calls might go something like, hey, we just found out that someone poured the wrong sanitizer in our beverage machine. We're worried consumers could be sick. Or we just found out that somebody put peanuts in the sun butter and that's nowhere on the label. Or we just got a presumptive positive test from a customer for Listeria, E. coli, or Salmonella. We aren't sure if it was taken from a food that was even ours. We aren't sure if that sample came from the floor. We don't really know. We don't know what species it is. And so those types of events are usually the ones that set off a company to really start being concerned about, where did we go wrong? How did we go wrong? And what are we going to do? Now, we definitely said that these are things that might happen. I think the operative word there is definitely might be going wrong, because oftentimes when the initial panic goes away, what we find when we work with companies is either the event is not as bad as they thought in the first place, or they have sufficient procedures in place to address the situation and to resolve issues with the FDA, which looks for voluntary compliance, or with customers before anything really progresses to significant liability. But there are times where FDA's inspections really do seem to be true investigations, right? It's not open and shut. It's not easy to work with the agency on a recall and get that recall terminated. And those are where most of us become much more concerned about whether or not the FDA is going to attempt to go further in its investigation of the company, and the role of in-house counsel and outside counsel in getting the company successfully through to the other side. And it's important to think about with this too, just one takeaway is that a lot of events are not reportable to FDA, but there is a whole other class of events with food products in particular, where the product could cause serious adverse health consequences or death. And in those situations, a company is working under a timeline. In fact, the FDA wants notification within 24 hours. And so while that's a nuanced analysis, when there's a potential problem with a food, it is something that requires fast action by the company to resolve and investigate. So to give a few basics of inspections, right? When that inspector shows up, what is the company really looking for? And the first is the FDA Form 482, a notice of inspection. Form 484 is going to be the receipt for samples collected. And Many would recommend that a company also have its own samples, that they go right behind that inspector, collect at the same time, and work with counsel to get those tested for similar types of issues the agency itself might be looking for. But the one main takeaway to teach everyone who might be involved, and usually there's going to be inspection procedures, there'll be practice, but everybody should know not to sign the agency's affidavit. Most companies will have already had a pretty extensive set of procedures and all their personnel will be trained, but still inspectors can be pretty aggressive about trying to get a company, and particularly maybe a lower level plant or production employee, to try to sign an affidavit. And so that's really the single most important thing to remember during the inspection itself. And so, Bill, I'm going to turn this over to you to help us understand some of the ins and outs to requests for information by the FDA, and whether or not the prosecution that's now about 10 years old, maybe more, of a former GSK Associate General Counsel allegedly for not sharing information with the FDA has relevance for in-house attorneys today.
Thanks for having me. This is where a lot of people think that the presentation gets scary, but I think it's really the previous screens with all the regulations that really trigger my area of practice, which is responding to government investigations and government subpoenas. And it is tricky, and because this is the ethics part of our CLE today, I am going to drop a couple of model rules just so we comply. We're going to be talking about the preamble to the model rules, which require us to be a zealot advocate for our clients. That's changed a little bit, the language. Rule 1.6, which is confidential communications with the potential of waiver. And then at some point, maybe candor to the tribunal comes in here. So the question is, once the government gets involved, and the way this happens is so that the FDA will come in and do its investigation, and make no mistake that at that point you are dealing with the government. Statements made to the FDA, even though they may not ultimately be the one that's prosecuting you, the agency that's prosecuting you, those statements are still very, very important in your actions, your attitude, your strategy in dealing with the FDA is still very important. Ultimately, there would be, if there's any type of prosecution, there's referral to the Department of Justice, and that's where typically in-house counsel has organized a team, and then corporate counsel works with usually other experts and outside counsel. Perhaps outside counsel will retain experts as well to then put together your team to respond to the investigation. So the question in an investigation, any investigation, is does zealous advocacy expose corporate counsel to risk that outside counsel or others might not have? So we're going to talk about three things briefly that come into play when we're talking about these types of investigations. The answer to the question is potentially. There is risk for corporate counsel in dealing with the government, dealing with investigations. That in most instances, unless the outside counsel is in extraordinary circumstances are actually involved in perpetrating some fraud or submitting false information or lying to a tribunal, in most cases, they're not going to be exposed to the same types of things that corporate counsel would be exposed to. So the answer is potentially. So the three related theories, and Susie talked about two of them, and I'll throw in a third. The first that we'll talk about is the responsible corporate officer theory, or it's the Park Doctrine. It's from a case about 60 years ago, the Park case. And the theory has been around a long time, and it's been used, I would say sparingly, but most often in the food space. And when you hear government officials talk about their ability to use the Park Doctrine, they seem to reserve it for public welfare offenses, or those types of instances or violations of regulations that would cause a public safety event. For those of you who don't know, the Park Doctrine, it allows the government to use a strict liability theory for corporate officers for misdemeanor violations, which is super scary to think about criminal prosecution for strict liability. It's used when a corporate officer has the responsibility and the authority to either prevent a violation of a regulation or to quickly remedy it on the other end. It's primarily used, like I said, in violations of the FDCA or other types of public welfare offenses. If that's going to be the case, there's going to be a referral to the Department of Justice. The Department of Justice, because of the seriousness of using the Park Doctrine to prosecute individuals who were not personally involved in the wrongdoing, the Department of Justice centralizes the view of the Park Doctrine. So they take all those cases, they monitor all those cases to make sure that the line U.S. attorneys and the offices across the country are following DOJ guidelines in the prosecution of those cases. So that's the first thing to think about. There are lots of nuances that we won't get into because of time, but who qualifies as a corporate officer, a responsible person, who has the authority, who has the ability. Those are all of the things that come into play. And again, then it becomes a strict liability offense, which for us that defend these types of cases, that's the scariest part of it. Once the government proves those initial elements and then proves that there was in fact a violation of a regulation, then they've proven their case, which is quite scary. The second that Susie mentioned that I'll touch on is a risk of prosecution for corporate counsel for obstruction of justice or submission of false claims. This is something that happened. There was a case about 10 years ago with GlaxoSmithKline and the off-label promotion of Wellbutrin. Some of you remember that it was initially approved to treat depression, but the FDA thought that it was being used it was being promoted off-label for weight loss. And so they sent letters to a letter of inquiry to GSK asking them to voluntarily submit information regarding the issue. And so the lawyer, Lauren Stevens, put together a team of in-house counsel, outside counsel, and they investigated just like you would. That investigation led to hundreds of interviews, collection of large amounts of information from all over the country, from sales reps all over the country, evaluation of that material, lots of conversations with in-house and outside counsel, lots of consultation. And ultimately, it led to the submission of 6 substantive letters to the FDA. In those letters, they largely denied all of the allegations. And remember, this started as a completely voluntary exercise. All of the letters, importantly, were signed by Stevens. Remember, she was the corporate counsel. They were not signed by outside counsel. This was a voluntary submission to the FDA. But all of the letters, the substantive letters, as you would expect, were drafted by outside counsel. So as you may imagine, Stevens was indicted. She was indicted for obstruction of justice and for submission of false statements. The government's theory through the grand jury process. And so imagine for obstruction of justice, for those of you who aren't familiar with the criminal process, the Department of Justice will impanel a grand jury, and they are the counsel for the grand jury and provide legal advice to the grand jury as to whether return an indictment. It is a closed proceeding. They subpoena witnesses to come in to the grand jury to testify. The grand jury asks questions of the witnesses and then also asks questions of the prosecutors. And the prosecutors answer those questions. There is a transcript, which is important, but otherwise it's a closed proceeding. The grand jury returned an indictment and indicted the corporate counsel, who by this time was retired, but she still was indicted. Throughout the process, a couple of things that are important, and we talked about the advocacy part in the preamble to the model rules. We should also talk about Rule 1.6, which is the confidentiality of communications in the conducting of investigations. The government argued in that case that the attorney-client privilege did not apply because of the crime fraud exception. A magistrate judge ruled on that and allowed, based on an in-camera inspection, and basically all of the privileged materials were turned over to the government and then ultimately to the grand jury, and that many believe what led to the first indictment. A federal judge, after reviewing that and reviewing the indictment, struck that indictment, but 2 weeks later she was re-indicted. Ultimately, the case was tried, and there was what's called a Rule 29 order from the judge, which basically snatches the case out of the hands of the jury and acquits the defendant without the case actually going to the jury. And the findings were quite striking. So ultimately, counsel prevailed in that case. But the scary thing, and particularly at my time at Tenet, when I was counsel for these investigations and routinely interacted with the government and signed things like this, it's a very scary process that the government can choose to prosecute corporate counsel for the what we would consider advocacy on behalf of our client. There is legal advice given, there are strategies that are made, and most of that's done under Rule 1.6, which leads lawyers to believe their work product and their communications with their client. And as you know, as corporate counsel, your client is the company, that those communications will remain privileged. The difficulty in any investigation is in most instances, the investigations start off in a cooperative way, where you're providing information just like GSK did. They're providing information, providing what we call proffers, which are statements of witnesses that are made through the attorneys and not directly by the witness. Those are called proffers. And you are exchanging information, trying to be cooperative. What counsel should always keep in mind, and what's I think important for this group, is that there may be decision at some point to waive the attorney-client privilege and to provide information, particularly if you're going to rely on an advice of counsel defense. Now, in this case, with the indicted lawyer, the government argued, and the initial court found that the advice of counsel defense was not available because it was a specific intent crime, and therefore the advice of counsel defense was not available. And so it really created a conundrum. Now, ultimately, as I said, the in-house lawyer was acquitted, but it does not mean that she got off for free. She had it was a tremendous and troublesome time for her as she faced multiple indictments, legal fees, and all of those things. So it is a risk. The judge did admonish the DOJ about these types of prosecutions. We've seen them threatened over the years. We've certainly heard the government discuss the ability to use this authority to charge corporate counsel with obstruction of justice and submission of false statements, 1001. And so just be aware that it's out there. The third thing that I would say that kind of comes into play here is many of you probably heard about the Yates memo. This was Assistant Attorney General Sally Yates, who in 2015 issued a memo that really changed the landscape for corporate prosecutions. And the purpose of the Yates memo was to shift the focus for U.S. attorneys' offices from prosecution of corporations who, as you can imagine, can't be sentenced. They can be fined, but they can't go to jail. And so the Yates memo essentially said that in order to deter corporate wrongdoing, we've got to focus on individuals. And so the shorthand was, if we can't, we need to start putting people in jail, and that's going to deter corporate wrongdoing. There have been a couple of modifications of the memo. Initially, when it came out, the import of the memo was you either turn over all of the individuals that you believe were responsible for wrongdoing, and you got no cooperation credit. That's been walked back a little bit, but you can imagine the tension here. So we've talked about being prosecuted under the Park Doctrine, and we've talked about perhaps counsel's risk in association with these investigations. And then you put the Yates memo on top of that, and it really creates a tension because the government is asking, as part of the company's cooperation, that you identify people responsible for wrongdoing. And so you can imagine that you are talking with your leadership at your company, and you're in one of these investigations, and you're trying to make the decision about whether to disclose to the government an individual in one of these FDA investigations who perhaps was responsible, and that person could report to one of the leaderships, and then you may expose the leadership then to liability under one of these theories. And so it really creates a lot of tension between the company and its employees. Now, I'm not too sure that that's not the intended consequence of this, that tension be created, but it certainly is a strategic call for you and for your outside counsel to discuss about the how you cooperate, and in some points whether cooperation is in your best interest, and instead that you should just prepare a defense to what would likely be a continuing either civil or criminal process. So the other thing before I turn this over to keep in mind is the government puts a lot of importance on corporate compliance programs in all aspects of companies' compliance, but certainly in areas where the government regulates the conduct. And so to the extent that your company does not have a strong compliance program, that certainly is going to be a consideration in each of these theories as to whether the government moves forward or not. If there's a referral, a strong compliance program really goes a long way, and the evaluation of those compliance programs is very sophisticated now. The DOJ Main Justice has professionals that this is what they do and this is what they evaluate on a daily basis, and so it's very sophisticated. The last thing I will say before turning it over is the role of whistleblowers in all of this. Just know, with the proliferation of False Claims Act cases, and then and the sophistication of most corporate compliance programs that encourage I'm not going to say whistleblowing, but a see it, say it mentality, where you report up the chain either through your supervisor or through a compliance hotline or an independently monitored system where you report wrongdoing. That whistleblowing, a lot of times these people are going straight to the government. And so when the government is involved in these investigations, they already have specific knowledge and information that was been relayed to them by a company insider. And depending on the area that you're in, and I've seen some of your email addresses, so I know some of your companies and some of the industries, there are specific whistleblower protections and lots of regulations. And I know that the topic we're speaking on today on food law, that there is specific whistleblower protections that will protect the whistleblower. So that has really upped the ante in all of these types of investigations because of the nature of the referrals, because of the way the information came to the government, and the head start that they may have on you as counsel as you start the process.
I'm going to hopefully liven things up a little because my part is a a little less solemn, although I do get to talk about things that go wrong. We only have about 10 minutes together, you and I, to talk about advertising. So it is going to be a very broad overview of some general concepts for evaluating advertisements, what can be challenged, some things that have gone wrong, some things that have gone right, but mostly things that have gone wrong. But let's start at that 30,000 foot level. Something that I just want to be very clear about: advertising is regulated speech, and advertising these days is any statement a company makes regardless of the medium, right? So we have so many unconventional forms of advertising now, whether it's sure through social media, native advertising that even looks like an article, but is actually a paid sponsored ad on behalf of a company or a brand. And then of course we still have traditional advertising. We have radio, we have television, magazine ads, but your antennas have to be up for any type of message that's conveyed to the public. That is an act that absolutely is regulated speech, and can potentially be challenged. And remember, statements made on behalf of the company, even if they don't come directly from the company, can also come under scrutiny. Big one these days, marketing through influencers. I would be surprised if the vast majority of you haven't already done some marketing through, whether it's micro influencers or some major names at this point. And then marketing through employees. There are absolutely connections and disclosures that need to be made clear when these statements are being viewed by the public. So whether the statement is coming from the company itself or through third parties promoting the company, these are all types of regulated speech. My example here is one of my favorites. Palm Wonderful. I don't know how much you guys know about their run-ins with the FTC, their incredibly aggressive advertising tactics, but you can tell from the noose around the bottle of juice itself and the words cheat death that this did raise the FTC's hackles. Anytime you make a claim like this, right, that your product can cheat death, can cause a consumer to live longer, this is going to be a high risk area, but we'll get into that a little bit later. So general rule of standards for advertising. Okay, say it along with me. I think we all know this, right? False, misleading, or deceptive ads are prohibited, especially when the false statement or deception in question could influence a consumer's conduct or decision, right? And that's what makes it material. If your deception or your false statement or your misleading messages are not going to influence a purchasing decision, there is a defense. In general, these types of claims do tend to be material. And remember, an omission of material fact can render an ad misleading. We'll see a good example of that later. You have to consider the overall net impression of the ad. So step back, listen to what the ad is implying, as well as the words that are coming across the screen. So ads can communicate information through various means: text, images, sounds, etc. Your ad must be truthful and not misleading, and they are not the same thing. One of my favorite examples of this, where something was technically true, but was definitely misleading. There's a muffin mix company who claimed that their chocolate chips were 50% more than the leading competitor's muffin mix brand. Turns out, yes, in fact, their chocolate chips, they had 50% more chocolate chips. However, these chips were minuscule. And so my 10-year-old self would look at that claim and think, and I think all of our 10-year-old selves would think, ooh, more chocolate in that muffin mix, right? If you've got 50% more chocolate chip than the leading muffin mix brand, there's going to be more chocolate in that, but that wasn't the case. And so while that ad was technically truthful, it was misleading in its message. So look at both, right? Any claim you make in an ad must be substantiated. There must be support. There are different types of substantiation, everything from what the reasonable consumer would expect, all the way to double-blind, placebo-controlled clinical tests being the gold standard. And you'll see more of that in health-related claims, which probably do cross many of your paths. And of course, your ad, in addition to the following, must be otherwise lawful. They have to meet labeling standards. You have to have disclaimer or disclosures in certain cases. Industry regulations will impact what type of information you share. So there are a lot of I's to dot when you are evaluating an advertisement. I do have a quick, just 5 bullet point checklist. I believe that these slides are going to be made available to you. So hopefully this is something that can be referenced, because today we really only have time to focus on number 1, which is identifying all express and implied claims that are made. As a company, you are responsible for all of the messages that are being conveyed by your ads, whether or not they're blatant on its face, like express ads, or messages that are being sent by implication. Determine if the claims are material, step number 2. Step number 3, determine if there is sufficient substantiation or evidence to support the claim. And what type of evidence did you need? What type of substantiation do you need? Does it rise to the level of supporting the claim? Consider the overall impression of the ad for any unintended messages in particular, and then review for any special issues. So kind of a broad checklist, but let's dive into number 1, because that can bring with it some surprises. So express claims are exactly what you're thinking, right? They're typically written, stated orally. 100% cashmere is an example because kills 99.99% of germs. And I've got an example right in front of you here. 1 a day men's multivitamins. We've got a list of things here, complete multivitamin to support heart health, immune health, physical energy, healthy blood pressure, healthy muscle function, and you better believe their lawyers were all over this label, right? Making sure that all of the tests, all of the clinical trials had been done that were narrowly tailored, that supported these claims. And then what happens? There is an additional claim on this bottle that not even the lawyers saw. And I'm not going to ask if you guys can guess because I don't have the function with all of your texts up, but one particular claim and a class action lawsuit took this company by surprise. And the problem was, you have a vitamin called 1 a day, and the serving size was 2 gummies, and in some cases 2 pills. So the court didn't buy any of the defenses that Bayer begged the court to take, and the class action suit was resolved in favor of the plaintiffs, the class of vitamin purchasing consumers. You cannot call your vitamin 1 a day if you're requiring customers to take 2 a day. And this is just an example of how subtle some of these express claims can be. So don't rest on your laurels, right? Examine every text that crosses your path. This one's very easy, right? French's ketchup, free from preservatives, artificial flavors, high fructose corn syrup. We know their food lawyers are all over those, making sure that they're adequately substantiated. But then what did they do? These guys put out a TV ad as part of that exact same campaign. So let's watch this.
You want your own ketchup? Yeah, I promise cross my mom out stuff of high fructose corn syrup.
Moms know best. French's has no high fructose corn syrup.
Tastes great.
French's, only real ingredients.
So we have some express claims here, right? No high fructose corn syrup, etc. And then we've got two little kids that are talking. And one of them says, I promised my mom I'd stay off of high fructose corn syrup. I mean, he's not talking about drugs, not talking about tobacco or alcohol. He's talking about high fructose corn syrup. Well, Haynes had a problem with this. They said that French's, what you don't realize is that you're implying that ketchup with high fructose corn syrup is unhealthy. And the NAD in this case, this was brought in an industry regulated forum. The NAD sided with Haynes and said, yes, that absolutely is an implied claim here. And French's had to modify the implied claim in their ad. Since we only have a few minutes left, one of the messages that I very much wanted to get across, because you're going to be dealing with your business people, your marketing folks, they're very creative. They're going to want to push the boundaries, right? And sometimes they think they're being very clever. If they think they're being too clever, they may be, right? They think, oh, nobody's, we're going to hint, nudge, nudge, wink, wink. We're going to get this message across. Well, guess what? That message is likely getting across. And if it's not something that's substantiated, right? If it's not a message that doesn't have the testing necessary behind it, the evidence and the support that it needs in order to be a substantiated claim, it could very well get the company in trouble. So examples of implied claims, say a sunscreen that says blocks rays and that cause sunburn. Well, the implied claim is that it prevents sunburns. Very easy. Kills the germs that causes cold. Okay, this product, if you use this product, it will prevent colds. And then there was this ad by Budweiser. It was aired in the Super Bowl a couple years ago.
That's not ours. We don't brew Bud Light with corn syrup.
Miller Lite uses corn syrup.
Let us take it to them at once. But if something did happen, we'd eat the wizard first, right?
Yes. Oh, yes.
Oh, brewers of Miller Lite, we received your corn syrup by mistake.
That's not our corn syrup. We received our shipment this morning.
You're joking.
Try the Coors Light capsule. They also use corn syrup.
Can you smoke outside?
Oh, brewers of Coors Light, is this corn syrup yours?
Well, well, well. Looks like the corn syrup has come home to be brewed. To be clear, we brew Coors Light with corn syrup.
Bud Light, brewed with no corn syrup.
And again, this is one of those ads that is technically true, but misleading. And you can imagine that Miller, the second this thing aired, had their team of lawyers going, looking through this, looking through every potential implied claim, wanting to challenge this. And what Miller's lawyers said was the impression that this ad gives is not only that Miller and Coors brews their beer with corn syrup, but that corn syrup actually remains in the beer after the brewing process, which wasn't the case. And so we have Budweiser beer without corn syrup in the end product, and we have Miller Lite products without corn syrup in the end product. It was used, the corn syrup is only used in the brewing process, and in that process evaporates or disappears. I'm no beer brewing expert by any means. And so Miller won, and Budweiser had to modify their ad. One of the things that I am always careful of is there are a lot of different media, a lot of different ideas that come with a single advertising campaign. Some ads might be perfectly fine, right? The one on the left here, brewed with no corn syrup. Miller Lite had no problem with that. Bud Light didn't end up having to change that. That was not challenged. The one on the right, however, conveys the same message as the TV ad did, which if you put a can of beer and the words, yes, corn syrup, any reasonable consumer is going to understand that there is corn syrup in that beer, which again, wasn't the case. And so that particular ad also had to be modified. So any additional words placed in the same ad campaign, any images added or subtracted can change the meaning of an ad and should be carefully reviewed each step of the process. Every time it's modified, sometimes even, your marketing folks might think it's not a big change. It might be 1 or 2 words. It might change the entire impression of the ad. It might add messages that weren't there before. And so making it clear that legal clearance is required each step of the way that a change is made is an important message to convey and work alongside your business people and helping them craft, creative, acceptable ads, not always being the bummer, of course, which we do our best not to be, but as you all know, sometimes we can't do anything other than say no. But I think that's a really good stopping point as we go into other examples here. But so I'm going to hand this off to Susie to sign off and thank everyone for us.
We are so glad we had the opportunity to work with all of you at ACC on this event, and we look forward to answering any follow-ups if you all need additional information on the topics we've talked about today.